22.
We're ready, Judge. Good afternoon. We're going to do position number 4.
Okay.
Come on, Mr. Lewis. Have a seat right here.
See, good afternoon.
Where's he at? Good afternoon. Where are you at?
Can you see me?
No. Yeah, I can see you. I can see you now.
Okay. All right. Good. Is it Munez?
Mr. Munez, yes.
Yes. Good afternoon. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
You what?
We are conducting this by video. Do you agree to have your case heard by video?
Yes, I guess. Yeah.
Okay, you've been charged in case 22 CR 001633E with criminal trespass. Is there a history, Mr. Howard?
I counted 10 total. Can they hear me? Can y'all hear me?
Yes.
She said yes.
Yes.
Okay. I got 2015 public drunk out of South Carolina. I got a problem conviction from 2013 South Carolina. Assault and battery first degree conviction, South Carolina. That was in 2011. Got a 2011 grand larceny conviction out of South Carolina. Neglect by legal custodian out of South Carolina. That was a conviction. That was 2011 also, an assault battery, high aggravated nature. That's it. And he's a resident of Greenville, South Carolina.
All right, Ms. Duncan?
Yes, Your Honor, this is position. which
4.
position? 4. Yes.
Your Honor, I'm sorry, if I may interrupt just to give Ms. Duncan some information.
Okay.
The state was unaware of the defendant's history in South Carolina. We did not have that history. So given that pretrial has indicated this defendant has a history, we did make a plea recommendation that we are now withdrawing. The defendant never accepted the plea recommendation, so we are permitted to withdraw that recommendation at this time. And I am asking Ms. Duncan to proceed with a surety bond given the prior history.
Okay. Ms. Duncan?
Yes, Your Honor, this incident took place at the Candler Hotel, which is located at 127 Peachtree Street on March 21st, 2022 at about 7:30 in the morning. Officers were dispatched to the location where the defendant was located on the property after being issued a prior warning earlier by the Director of Security to leave the property. The Director of Security, my apologies, approached the defendant and asked him to leave several times, and he refused to do so. Given the facts in this case, we are going to recommend a $2,000 surety bond, a stay away from the incident location, no alcohol, drugs, or weapons.
All right. Ms. Kim?
Yes, Your Honor, Mr. Muniz. He is 81. He was born 1981, so he's 41 years old, and he lives in South Carolina. He was passing by Georgia. The last anything that happened was 2015, which is 7 years ago. So we would like to request for signature bond for him. Thank you.
All right, per the state's recommendation, a $2,000 good bond. Stay away from the 127 Peachtree Street address. No drugs, alcohol, weapons while out on bond. Good luck to you, sir.
Thank you.
Yes. We got position number 2, Mr. Gist.
Good afternoon, Mr. Gist. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Gist, you've been charged in case 22 CR 001631Y with battery substantial physical harm. Is there a history?
25 total. Last arrest was 2013. Possession of a Schedule 1 controlled substance. Possession of a Schedule 1 or 2 controlled substance with intent. Possession of meth. Possession of meth with intent. Selling marijuana. He went to prison. They gave him a 10-year sentence for that. He got a parole hold as well. As far as violence, you have a simple battery conviction from 03, battery conviction 04, battery arrest from 05. Most of the history is drugs. That's it.
All right. Afternoon, Ms. Webb.
Good afternoon, Your Honor. Let's see. Yes, Your Honor, this incident occurred on January the 14th, 2022 at an incident location of 1575 Ralph David Abernathy Boulevard Southwest, where the Atlanta Police Department responded to a dispute call, and they were met with the victim, Mr. Joseph Victor. That's Joseph, common spelling, Victor, common spelling. Mr. Victor informed the officers that he and the defendant were sitting and having a conversation with others when the defendant impeded in on his conversation with someone else who was sitting in the circle regarding a personal matter with his girlfriend. When he asked the defendant why he was intruding on his conversation because he was not speaking to him directly, the defendant got up and punched him on the left side of his forehead. When the police responded, because of Mr. Victor's age, they did request for medical attention because he was complaining of a headache, a severe headache, and he was transported to the hospital for further evaluation. Your Honor, for those reasons, the state is recommending $2,500 surety bond, no further contact with Mr. Joseph Victor, a stay away from that incident location, no alcohol, drugs, or weapons, and 1-day anger awareness. Your Honor, our office did get a chance to speak with Mr. Victor, and he said this is not the first time that he and the defendant have had a physical altercation, and that the defendant has expressed his disdain for the victim for whatever reasons, but that this attack did result into a knot on the back of his head, and he had to go to the hospital to be treated for that severe headache. For those reasons, Your Honor, and as you've heard from pretrial as well, considering the defendant's history, including that battery arrest from 2005 in Fulton and simple assault from 2012, we do believe that there's a risk of reoffending. Nothing further.
Thank you. Good afternoon, Ms. Gann.
Good afternoon, Your Honor. Mr. Delano just is 60 years old. He has been in the Atlanta area for at least 30 years. He has family here, including aunts and cousins. Your Honor, we are opposed to the stay away at 1575 Ralph Abernathy Boulevard. Mr. just informs me that this is a social club and that he has been attending this club for the past 30 years. And he believes that Mr. Joseph Victor is barred from that club. However, Your Honor, I was unable to confirm that. Mr. Gist is a high school graduate. Currently, he is a truck driver. He works for Mass Construction Demolition Company. He has been in that position since 2020. Your Honor, he denies the allegations. He states that there was an altercation with Mr. Victor. He states that Mr. Victor had attacked a female patron there. He came to the female patron's aid. Mr. Victor then attacked him. He states that he swung on him, and Mr. just more so acted in self-defense. He states that there are plenty of witnesses who witnessed this incident. He states that there's an off-duty police officer there, and he believes that the off-duty officer arrested him because he is a few years older than Mr. Gist. Regarding the parole violation, Your Honor, Mr. Just states that he was unaware of this warrant. He states that he learned of it when he was stopped a few days ago for a traffic violation. He turned himself in, and he states that he had been in contact with his parole officer to inform her of this incident, and that his parole officer had been updating him on whether or not a new warrant had been issued. And he states that he did not receive any notifications. Your Honor, I do acknowledge my client's history. However, I do believe that simple batteries from 2003 and 2004 are a bit remote for this court to consider. And as we heard from pretrial, most of my client's convictions have been for drug-related offenses, and even those are fairly remote. For these reasons, Your Honor, I am requesting a signature bond. We are again opposed to the stay away. However, we are unopposed to the no contact order, and we are requesting a signature bond. And if Your Honor determines that he is ineligible, then a bond of no more than $1,000. Thank you.
It's going to be a $1,500 good bond, no further contact with Joseph Victor, stay away from 1575 Ralph David Abernathy, no drugs or alcohol or weapons while out on bond. Good luck to you, Mr. Gist.
Thank you, Your Honor.
Next, we have position 7, Mr. Villara.
Judge,
Yes.
Judge, I was appointed to that, but when I had a conversation with him, he said he's represented by Judy Kim, and I left a message with his family.
Thank you, Mr. Murphy. Mr. Villada, I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
You've been charged in case 22 CR 001637Y with simple battery family violence. Are you represented by, it's my understanding, Attorney Kemp?
Judy Kim.
Judy Kemp?
Yes, that's what he told me, Judge.
Are you represented by Ms. Kemp? Courtroom 2, you're on mute.
Talk to her. I do believe so, yes.
Okay, well, I asked you that because you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. If you can't afford an attorney, one can be appointed for you. We did have Mr. Murphy here to represent you. Given that Ms. Kemp does not appear to be on the line this afternoon, you would either have to wait until tomorrow to when she could be contacted and could be here, or you would have to proceed pro se, or you could utilize the services of Mr. Murphy.
Your Honor, I believe Mr. Murphy is referring to PDJ Kim.
Oh, Ms. Kim, not.
No, it's Judy Kim. It's Judy Kim. He hired a private attorney. It's not Judy.
Yes, yes.
Okay.
That's what he told me.
Okay.
All right. So with those options, sir, to wait till tomorrow to get in touch with your attorney if you've hired her. If you paid her and hired her, that's one thing. If you haven't, then you can use the services of Mr. Murphy, or you can proceed pro se.
Because she was approached by a family member and I have authorized payment, but I am uncertain. Would it be possible that I proceed with the provided attorney while I arrange a formal lawyer?
Mr. Murphy?
Yes, Judge, I'll be ready to, if that's the scenario, I'd like to just address the issue of bond.
Okay. Let me hear from Ms. Duncan first. I'm sorry, let me hear from pretrial first. Is there history?
I got first already.
Okay. Ms. Duncan?
Yes, Your Honor, this incident took place at 463 Patterson Avenue Southeast. The victim in this case is Ms. Josemarie Castillo, first name spelled Jomarys, Castillo spelled Castillo. The victim in this case was the other person formerly living in the same household as the defendant. These incidents were reported in February of 2022, but the incidents relating to this report took place over several days in the month of October. The victim went to the front desk at the Zone 6 Police Precinct at 2025 Hosea Williams Drive and reported the incidents to the officers on duty at that time. She stated to the officers that during the first week of October 2021, there was an incident between her and the defendant regarding a DJ that she had hired for a party. Seeing that the defendant was also a DJ, he became upset when he found out that she hired someone else, and he confronted her about it and slapped her in the face, leaving a small bruise and some swelling for a few days. After that incident, around October 13th, 2021, there was an incident with the defendant where he was looking for a pen and he couldn't find one in the drawer where the pens usually are located. He became upset at Ms. Castillo and she stated quietly that she would find him one. However, he reacted by forcing her to get out of the house and go sleep in the car that night. She stated to officers that around 4 a.m. she tried to sneak back into the guest room of the house. And he came in and threw the covers off of her. And he said, "What the F do you think you are doing?" And he drug her out of the house by her hair and made her sleep in the car. She further stated that around October 18th, 2021, she was trying to send a friend a voice note about the incident from October 13th and accidentally sent it to the defendant. And that when she returned home, he confronted her about it and he punched her in the left eye and cheek, causing her to be knocked unconscious. She showed officers pictures at that time. She stated that her daughter, minor ZS, was inside the house when these incidents occurred, but she did not believe that she was able to hear or see the abuse happening. We are very concerned about the safety of this victim, Your Honor, and about the risk of intimidation of this witness. Our victim advocate was able to contact the victim, and she stated that they had been in a relationship for about 8 years, and he had been abusive throughout the entirety of the relationship. She said that they're currently not in a relationship anymore, and she does not live with him. However, she is concerned for her safety. Just in case the defense sees an issue with the amount of time between the reporting and the actual incidents, she said that after the last incident, she was so afraid for her life, she fled back to Puerto Rico with her family and to seek refuge because she was too afraid of the defendant in this case. While she was in Puerto Rico, she said that she sought counseling. And when she came back to the States in February, as I mentioned, she had heard from people at the place where they used to work that he was going around and telling people that he had and gloating about hitting her and getting away with it. So because she had went to counseling and gathered strength to speak up for herself, and her family encouraged her and supported her in doing so, she went to the precinct and reported the events as I've recited them to the court today. She also notified our victim advocate that apparently he's done this before to other women, and she just does not want this to happen. Due to the severity of the offenses alleged in this case, we're concerned for the safety of the victim and intimidation of the witness. And due to the fact that she was actually knocked unconscious in one of these incidents, the state is requesting a $4,000 surety bond, no further contact with the victim in this case, a stay away from where the victim resides. I don't want to state her address due to the nature of the offense. 1 day anger awareness, no alcohol, drugs, or weapons. Nothing further from the state.
Ms. Duncan, you've listed a number of, I've got one simple battery, family violence. Which one is that associated with?
They lumped them all into one incident because it was one report, but in the report, there were 3 instances.
Mr. Murphy?
Judge, we're talking about one incident. The alleged victim left the continental United States out of allegedly fearing for her safety and then returned. My client had a relationship with this alleged victim for 8 years. She no longer resides there, has not come back there, and wanted to come back. He did not want her to return. They do not have children together. They're not married together. They're not employed together. My client's self-employed. They do not have any joint assets. He has no criminal history. We have a gap from October till now, 5 months, Judge. I'd ask the court to consider a signature bond. He has no immediate people to get him out at this point. Although I've tried to reach out to his family to reach counsel, Ms. Kim, but at this point, I'm operating under the assumption that we have no one behind him to assist him, and I ask the court to consider a signature bond given no history and the gap between this alleged incident and today. Judge, if you consider a signature bond. Thank you. If I may add, with your permission.
Mr. You have a right to remain silent. Anything you say can be used against you. I would imagine that's what Mr. Murphy would instruct you to do. Correct, Mr. Murphy?
That's correct. We've had our hearing. Please remain silent, Mr. Valletta.
Your Honor, if I may, excuse me for the interruption. To clarify, the state is going to be, now that we have the report, we're going to be reaccusing the separate instances. But for the sake of today's hearing, we'll take the latest in time incident, which is the October 18th incident, as the basis for the charges today.
Thank you. Let's see, a $3,000 signature bond through pretrial, one-day anger awareness class, no further contact with Ms. Castillo, stay away from the 463 Patterson Avenue address, no drugs, alcohol, or weapons while out on bond.
To clarify, Your Honor, that's his address, the 463.
Yes.
She doesn't live there.
That's what I was getting at, Judge, is that I believe that that's his home address and that's his real property, and she's not on any deed or any lease.
She's not there. She has another address where she lives, but I didn't state it because of the nature of the offenses.
But he will stay away from her and honor the directions of the court, Your Honor.
All right, very good. Good luck to you, sir.
Thank you. Thank you, Judge. Your Honor, I believe that's all I have. The other case was, or I'm sorry, I have one more. I'll stand by. Forgive me.
All right, thank you. Who do we have next?
We have position number 3, Mr. John Johnson.
Good afternoon, Mr. Johnson. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Mr. Johnson, you've been charged in case 22 CR 001632J with simple battery. Is your history, Mr. Howard?
36 total. On probation, 2 counts of added assault with deadly weapon. 18 SC 159613. He gave me 4 years and 4 months probation for that in December 2018. Last arrest was January 2020, probation violation. He was arrested in 2019, felony theft by receiving. 2018, possession of cocaine. 2018, simple assault. 2017, FTA, possession of cocaine. 2016, probation violation. 2015, FTA. You got the FTA one out of the case. One more?
You're good. Thank you. Ms. Webb?
Yes, Your Honor. This incident took place on March the 21st, 2022 at 1456 South Gordon Street, Southwest Atlanta, where Atlanta Police Department responded to a domestic dispute call, and they were met by the defendant upon their arrival at the incident location. The defendant informed the officer that he had an argument with his girlfriend, who is the victim in this case, Miss, I'm going to spell out the first name. It's TRAEBBYIA Perry. Perry is common spelling. That he had an argument with Miss Perry that evening. The defendant advised that another male was at the home and was attempting to kick him out, and also told the officer that he struggles with substance abuse and was drinking that evening during the argument. According to Miss Perry, however, the couple got into an argument after returning from a grocery store run, and the defendant became upset with her and slapped her in the face with an open hand, and that her friend was at her home, Mr. Alexander, and broke up that altercation. Your Honor, based on the defendant's history for aggravated assault, which is the case of convicted case out of Fulton County from 2020, the state is recommending the $4,000 surety bond, no further contact with Ms. Perry, a stay away from that incident location at 1456 South Gordon Street, no alcohol, drugs, or weapons, and 1 day anger awareness. Your Honor, we are concerned that the defendant has a risk of reoffending, and in addition to that, he is a possible flight risk. As you have heard from pretrial, he has FTA'd out of Fulton in 2012, 13, 2015, 2017, and as well as in DeKalb County, Your Honor. So for those reasons, that is the basis for the state's recommendation today.
Thank you. Ms. Gant?
Thank you, Your Honor. Mr. John Johnson is 42 years old. He has been in the Atlanta area his entire life. He has family here, including his 6 children. Children are ages 18, 17, 15, 11, 12, and 9. He states that he pays child support for some of the children. Your Honor, we are unopposed to the stay away at 1456 Gordon Street. We also do not need a law enforcement escort. Mr. Johnson informs me that he does not have any belongings there and that he does not want any contact with Miss Perry. Your Honor, Mr. Johnson completed high school. He is currently unemployed and has been so for the past 2 months. He states that he is healing from injuries to his eye and lip that prevent him from pursuing his past area of employment. Your Honor, he denies the allegations. He states that the gentleman there pulled a knife on him and that Miss Perry ripped his shirt and he merely was acting in self-defense. While I acknowledge my client's history, I would like to bring to the court's attention that the aggravated assault conviction was in 2018. He states that some of the FTAs were because he was homeless and did not have the means to update the court. However, he understands that it certainly is his responsibility to keep the court apprised. Mr. Johnson also has some ongoing health issues that we are in the process of working with our social worker to connect him to services to address some of those needs. Your Honor, for these reasons, I am requesting a signature bond on Mr. Johnson's behalf so that he may deal with that Barron County hold and decap. And Your Honor, if you're unable to grant a signature bond, then we would request the lowest bond possible. Again, we are unopposed to the no contact and stay away orders. And Your Honor, if I may, regarding the foreign hold, he states that he had been going by that courtroom, but at least 3 times, but the court was closed, and that is why he failed to show for that. Thank you, Your Honor.
All right, it'll be a $2,000 good bond. No further contact with Ms. Perry. Stay away from the South Gordon Street address. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Johnson.
Thank you, Your Honor.
Next, we have position 5, Mr. Salam. Mr. Salam? Mr. Salam? Mr. Salam? Thank you, sis. Come on, sir. Yeah, come over here to the front. So you can.
While that inmate's coming up, Judge, I just want to inquire and make sure that my client is there. I represent Mr. Kedrick Baker, who turned himself in last night, and I've communicated with the magistrate court this morning, was told to come to this hearing at 2 o'clock rather than the 11 a.m. first appearance.
Okay, I don't see Mr. Baker on my calendar today, counsel. As soon as they get situated in the courtroom 2, I'll inquire.
Thank you very much.
I was going to ask if Mr. Schiffer could spell the name for me and I can look it up in the jail system.
It's Kedrick, Kedrick, Baker, Baker, 1 count of battery, substantial physical harm. It's non-DV.
Okay, I can look it up from there. Thank you.
All right, thank you, Ms. Falk. We appreciate it. Good afternoon, Mr. Salam. I'm Judge Eric Mora. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 22 CR 001590F with criminal trespass. Your history, Mr. Howard?
16 total. Yes, history out of New Jersey, Washington, North Carolina. I'm out of Florida. Convicted for a CWAC charge early 2000s. Last arrest was 2014. CWAC charge. It was real old. Early 2000s, 90s and 80s.
Okay, thank you, Ms. Howard. Ms. Webb?
Yes, Your Honor. The state did make a plea offer to Mr. Wellborn, Mr. Salam, excuse me. I wasn't for sure if PD Kim had an announcement.
Actually, he refused to accept that plea offer, so I'm here to represent for his bond.
Okay. Yes, Your Honor. This incident took place on March the 20th at MARTA at the 5 Point Station, where MARTA police responded to a disorderly person call, and upon their investigation discovered the defendant entered the southbound MARTA train tracks without having permission and remained in that area while retrieving some miscellaneous items. Your Honor, the state is recommending a $2,500 signature bond with a stay away condition at the MARTA at 5 Point Station at 30 Alabama Street, Atlanta, Georgia, with no alcohol, drugs, or weapons as a condition, Your Honor. Nothing further.
No objection, Your Honor.
All right, $2,500 signature bond, stay away from the 5 Points MARTA station, no drugs, alcohol, weapons, while out on bond. Good luck to you, Mr. Salon.
Thank you.
Your Honor, the state has an announcement on Kedrick Baker.
Through the jail.
Thank you.
Okay, thank you. Ms. Falk, go ahead.
Mr. Baker was booked in at 8:48 a.m. this morning, which was after the cutoff for first appearance SCA, which is the reason he has not appeared on today's calendar. So he will be on tomorrow morning, the calendar for tomorrow's state expedited accusations calendar.
He arrived at the jail last night before 8 p.m. And his family, like, we hand walked this all the way through. That is very disconcerting. This is a walk-in, prearranged, hey, you're going to turn yourself in. 8:43 in the morning is very challenging to hear, considering literally I spoke to him and his family on the phone as he was walking up to Rice Street.
Right. I will say I'm looking at the jail intake information. I can't tell you why. I can only tell you I'm seeing an arrest date of 3/22 at 8:48 a.m., book-in time 8:50 a.m.
Judge, this is a very straightforward non-DV case. I understand, as I believe everybody does here, the jail is under extraordinary stresses. I would ask that this case, as has been done before, be granted a bond and get him out rather than expose him unnecessarily. I believe this gentleman has little to no criminal record. He was contacted by a detective, hired private counsel. We walked him in well in advance of the calendar with the specific intention and schedule to have him on the 11 o'clock calendar. I was told he was on the 2 o'clock calendar. And his family and everybody else is waiting for him to be released. And while I understand I practiced in the jail for 20 years, it is absolutely challenging as a citizen practitioner to see the jail's inability to process inmates in a timely manner, prevent this gentleman from being released on a bond he is entitled to as a matter of law, and also expose himself to the health conditions down in the Fulton County Jail. This man is a professional and a worker and has a full-time job.
And Your Honor, as I'm sure the court and Mr. Schiffer understand, under Marcy's law, we absolutely have a duty to notify the victim of any court proceedings that are going on, which we have not had an opportunity to do, as this is the first time I am hearing about this case.
Judge, I'm happy to sit and me and Madam DA can call, or Madam Solicitor can call the detective and the victim. I don't even know if the victim's in town anymore. This is a non-DV. It's an ex-girlfriend. They were out together, and it's not accused as a DV. I believe specifically the state has all of the contact information for everyone in their file with them at court. That's what Mr. Gamage has promised me, that they would have this contact information in the files. And I would ask that the court allow Madam Solicitor to contact that victim in court and satisfy the Marcy's Law requirement, which she's absolutely correct. They do have requirements with that. But it's unconscionable to think that the system's failings are punishing a citizen who's trying to do the best thing.
Okay, well, let me just say that I can't do anything. So let me see if the jail can do something. Courtroom 2, is it possible that you're able to get Mr. Baker today? Ms. Falk, is it possible that you all can get together and call the victims today? If they can't get him today, then there's nothing more that I can do. And I know that there are numerous court hearings going on all the time with the jail. So if they say no, then there's nothing more that I can do. If they can get him, then I'm happy to work with you all.
Thank you, Judge.
is it possible to locate Mr. Baker? Courtroom 2 or courtroom 3, anybody can respond to me.
He's not on the.
Yeah, he's not on the calendar.
So
I understand that, but have you been listening to the conversation? If you tell me that it's not possible, then that's all I have to go with.
Hold on one moment, Judge, okay?
Okay.
I'll get my lieutenant. One moment for me, okay?
Okay, I
Can we go
appreciate
to the next case, please? And just hold for me one moment, Judge.
Okay, very
Thank
good.
you.
Thank you all.
And in the meantime, Ms. Falk, can you do whatever it is that you might need to do to be able to contact whomever you may need to contact?
Yes, I'm pulling up the information now and reading the warrant to see if I can locate the contact information in the warrant.
All right, very good, thank you.
So, do you have a history? I don't have a history.
At this point, we have absolutely nothing. So we're going to have to get an SG number, run a history, and get in contact with the victim. So this may take a while.
Okay, otherwise I'll go run.
Judge, I'm available. The court has my direct cell phone number. I can provide it to everybody else in chat. I'm
All right,
available.
so we'll do what we can. If we can, we can. If we can't, we can't today. So we'll do what we can. Right
Thank
now,
you very much.
You're welcome. We're going to move on with the calendar. Who do we have next? What's his name?
I'm sorry, Judge, before you start, I have my lieutenant in courtroom 3. Hello?
Oh, good afternoon. We have a complaint from an attorney regarding Mr. Baker, who was allegedly brought in or came in on his own yesterday at some time. He was allegedly not processed in, and he was supposed to be on this calendar today, but he's not on the calendar. My question to you all was if you'd be able to get him. If you can, we will try to move forward. If you can't, just let me know, and then we'll just have to do him tomorrow.
Yeah, I think it's gonna be best to do him tomorrow, because if he's not on the pull sheet, he didn't make the cutoff.
Judge, I've been practicing in this jail for 20 years. You have the ability and discretion to write him a bond. The prosecution has the ability to run this background. He's been in.
Well, I know what I have the ability to do. Okay, so that's, but if I don't have the facts of the case, listen, it's not just you. It's from the state also. I mean, I do the same for everybody, regardless of who they are. Okay, so I have to have the information so I can make the best decision possible. I would have to run a criminal history. We'd have to get in touch with the victim. So I appreciate what you tell me that you can tell me, but I don't need for everybody else to tell me what they can tell me. And I'm happy to do that, but but if the jail is not able to accommodate that, then there's nothing much more that I can do. So if the jail is able to accommodate, I'm happy to accommodate. If the jail is not able to accommodate, you all just let me know that, and we'll have to place this on tomorrow's calendar.
I would respectfully request you use your authority to order the jail to produce him with a background, which is what the jail, you have the authority to order them to do this. I've been working with magistrate court judges in this court since the time of Roy Roberts and all those guys. You have the ability to order the jail to do that.
Again, I know
there are a bunch of moving parts that I have no control over. I manage the staff that produces people for court. There are some other things that occur that I can't say whether or not they've occurred. And it may not be fair to all parties involved if there are victims involved, if there hasn't been time enough to interview witnesses or victims. So it's best to follow protocol. If he did not make the cutoff, he'll be in court tomorrow.
Judge, the Constitution appreciates the statements of the Fulton County Jail. He is constitutionally entitled to a misdemeanor bond. We proceeded, as we've done hundreds of times with clients, producing this individual well over 12 hours. And in fact, far more than 12 hours before his hearing. His lawyer appeared and contacted the court to confirm he was going to be on this calendar. I've told the family. I appreciate, I've been involved with Fulton County. I live here. I know every moving part. I represent a number of sheriffs. I even know that the sheriff's office hand-walked Paul Howard to see an inmate in person violating lots of standard operating procedures just last week. So I know that this jail has the ability to do lots of things for special citizens. And I'm asking that my client receive the same treatment.
All right, Ms. Falk, anything from you?
The only response I have to that, Your Honor, is Riverside does require that we have a hearing within 48 hours of arrest if the defendant has no warrant in place, and 72 hours if they do. At this point, there is a warrant for this defendant's arrest, in which we will have a hearing tomorrow, which will be approximately 36 hours after his arrest.
That's absolutely correct, Judge. No disagreement with Madam Prosecutor at all. I'm asking that this court serve the citizens of Fulton County best by moving people through it in an efficient and rapid manner. And if that means that the Fulton County Jail learns a message about how to operate, we've been trying to teach the jail that for over 20 years.
Okay.
If it was your family member, I hesitate to think how many people would be aware of the situation if it was mine or one of my patrons.
Okay, I hear you. He will be heard tomorrow. There's nothing more I can do. I see all these people as special people. You know, nobody is more special than the person sitting right there or any other person. I take it very seriously, as everyone in this court knows, with people sitting in jail. That, you know, but at the same time, I still understand that there are certain protocols and that the jail is under, you know, very difficult stress these days with the disease, with everything that they're dealing with. Okay, so I believe that it's best for this case that since it's not here today, since they will have difficulty getting here, since the lieutenant has already informed me of that we will hear him at the SEA calendar on tomorrow.
Thank you, Judge. That concludes my business in your honorable court. That SCA calendar is tomorrow at 2:00?
Yes, it is.
Thank you. Is this the same link that I should use, or should I source another link from the magistrate court?
Another link needs to be sourced. It'll be a different.
This will be the same link.
Oh, it's gonna be the same link. Okay, thank you, Ms. Lewis. Have a good.
Thank you very much. I appreciate everybody listening to me. I got to fight my fight for my clients, and I appreciate your professionalism and patience listening to me.
Very good. Have a good afternoon. We'll see you tomorrow.
Thank you. You as well.
Yes, Judge, real quick, what was position 5, the bond amount? Was it 2,500 signature bond through the jail?
It was 2,500 through the jail.
Thank you.
You're welcome.
Whenever you're ready, Judge, we have position 8. Mr. Warner.
Good afternoon, Mr. Warner. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir, and good afternoon.
Yeah. Mr. Warner, you've been charged in case 22 CR 001635J with battery family violence. Is there a history, Mr. Howard?
Right now, last arrest was 2020, added assault. He has an open case in state court for simple battery, cruelty in the third, 20 CR 005 264J. Ag assault open in Superior Court 20 SC 174160. Probation, 2 counts of ag assault. Possession of a knife during the commission, criminal damage to property, 1st degree. Case number 16 SC 140630. 15 years probation.
All right. Thank you, Mr. Howard. Ms. Duncan?
Yes, Your Honor. In addition to what pretrial has stated on those additional open cases in Superior Court, this defendant has previously received a $2,000 surety bond and a $3,000 surety bond for those alleged violent offenses. He additionally has a violent conviction where he's served 5 years and has 15 years probation. And with that context, I would like to let the court know for the record, this offense took place on March 13th, 2022 at 2070 Cheshire Bridge Road. Cheshire is spelled Cheshire, Bridge, common spelling. Road, common spelling. The victim in this case is Angel Stevens. Angel spelled Angel, my apologies. Last name Stevens, Stephens. Ms. Stevens is the parent of the same child with the defendant in this case. Police were dispatched due to a domestic dispute and they made contact with the victim in this case. The victim stated to officers at that time that there was an argument between herself and the defendant, and it ensued and escalated to the point where the defendant in this case punched the victim with a closed fist in the head, dragged her by her hair, bit her in her face and back, and knocked over all the belongings in her bathroom. This victim had visible injuries to her face and back, and she advised officers that the clothes that she was wearing during the altercation were ripped off of her. She stated that both of her children were present during the assault. We have no additional information as to if they heard the incidents at this time. The victim stated to officers that she is afraid for her life, and she at the time went and waited for officers in her car. She stated that while she was in her vehicle, the suspect followed her and began punching the vehicle before taking both of the children and leaving in another vehicle. The defendant was not on scene when officers arrived. Given the violent nature of the facts alleged in this case and the incidents as stated before and the history, we are concerned about this defendant's risk of reoffending due to the violent nature, as explained by the history, and the risk to this particular defendant and the safety of all those involved. For those reasons, we are requesting a bond in the amount of $5,000 surety. No further contact with the victim in this case. Third-party child contact, a stay away from the incident location, 1-day anger awareness, no alcohol, drugs, or weapons. Nothing further from the state.
Ms. Kim?
Yes, Your Honor. Mr. Warner is 27 years old and he lives in a separate place. So there's no need for a stay away, and he does not object to stay away anyway either. I had a chance to talk to Miss Angel Stephens, who is online here. She's not afraid of Mr. Warner, and I believe that no further violent contact would be enough. And he has been here in Georgia 27 years. He has 2 children with Miss Angel, 3 years old and 1 year old, and he is self-employed and he goes to college right now, and he has done that for 3 years. He's going through 4th year to get a diploma from Atlanta Institute of College. His major is fashion, and he makes custom shoes and clothes as a fashion artist. And last year he was locked up. He already paid for all those violation of probation and all those FTA. He already paid. He has served time more than a year in that jail. So I don't think he should be punished again for the same thing that he has just got out on December 15, 2021. He has learned how to get his housing. He has a job. He is pursuing his career in education, and the victim is not afraid of him, Your Honor. So we would like to request for signature bond. Thank you.
I'm sorry, Ms. Kim. I don't understand your argument that this happened on
March 13, 2022.
Right, of this year.
Yes.
And it's a new allegation, right? I mean,
right. Yeah. This one is new allegation, Your Honor.
So how was he?
When he was, usually we consider the history of what has happened when we decide the bond. So yes, there was all these allegations. I mean, there was previous arrest, FTA, probation, all those things. However, he served the times for all those already. So we just want the court not to consider them too heavily, Your Honor.
And Your Honor, if I may, again, the reason why we're asking for the $5,000 surety bond is based on his reoffense after being given a $2,000 surety bond and a $3,000 surety bond. As Ms. Kim mentioned herself, she doesn't believe that he should be punished for the same thing. However, he keeps doing the same thing where he was convicted in the past, served time, and was given probation. He continues to reoffend, and that's the state's basis for the bond as requested.
Okay. So it's going to be a $3,000 good bond, no further contact with Ms. Stevens, stay away from the Cheshire Bridge Road address, no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor. Nothing further.
Thank
Good
you, Your
luck
Honor.
to you. Who do we have next?
Next, we have position 9, Mr. Stevens.
That's my case, Judge.
Is that position 6?
Yeah, I was just gonna ask that. I have it as position 6 as well, Your Honor.
And just trying to clarify according to, like, I have position 6 as Rashad Stevens. Is that who we have?
They wrote the wrong number. I don't have the calendar with me.
Oh, okay, that's fine. But this is Rashad Stevens.
Yes, it is.
Okay.
Thank
Good
you.
afternoon. Good afternoon, Mr. Stevens. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir, Your Honor.
Thank you. Mr. Stevens, you've been charged in case 22 CR 001634F with simple battery. Is there a history, Mr. Howard?
44 total. On probation, possession of cocaine. I think they gave him like 25 years or 30 years, something like this. Last arrest was 2020. Felony obstruction, misdemeanor obstruction, simple battery. Simple battery is not presented to grand jury. January 2020, simple battery against police. 2019, battery dismissed. 2019, failure to appear for terrorist threats. Another 2019 FTA terrorist threat. Well, he got 2 more, so he got 4 total in 2019. 2018, probation violation, terrorist threats. 2017, parole violation. 2017, simple assault. Another 2017 parole violation, 2016 parole violation. You want me to stop?
You're good. Thank you. Ms. Webb?
Yes, Your Honor. This incident took place on March the 15th, 2022 at 307 University Avenue, Atlanta, Georgia. Atlanta Police Department were dispatched to the incident location and met with the defendant's niece, Miss Brianna Coffin. That's Brianna spelled BRIANNA, Coffin, COFFEN. Miss Coffin told the officers that her uncle came to the incident location, was laying on the ground next to her vehicle with an open container of alcohol. She came outside and told him that he had to leave that location because it was her mother's home and her grandmother was inside. The defendant got up and charged towards her at the porch, allegedly, and she retreated inside of the home where she told him to leave again and he refused. An unknown male was walking by and witnessing some of this take place and asked her if she needed assistance, and then the defendant turned and ran over to that male and began striking the male. Ms. Coffin then ran over to her uncle to get him off of that unknown male, Your Honor, and the defendant stopped for a second time and stopped briefly, and then began attacking that male again, and that is when she called the police. The defendant left that location momentarily and then came back, and while she was standing on the porch with her grandmother, the defendant came up to the porch and she attempted to protect her grandmother from him because she alleges that he has assaulted the grandmother in the past. The two began fighting. The defendant pulled her hair and they both fell to the ground. And she had scrapes on her knees from the fall, Your Honor. For those reasons, the state is recommending a $5,000 surety bond, asking the court to honor the preset $5,000 surety bond. No further contact with Miss Brianna Coffin. Stay away from that incident location at 307 University Avenue. No alcohol, drugs, or weapons, Your Honor. the state is making this recommendation because actually, Your Honor, this defendant appeared before you yesterday on a charge for battery against the same victim at the same incident location. That incident date, however, was March 1st, March 1st, 2022. And this incident occurred just 2 weeks later after that. Additionally, while incarcerated, Your Honor, the defendant in 2020, the defendant committed several violent offenses against law enforcement and EMS personnel while in custody, including obstruction, threats of violence against law enforcement, terroristic threats, and aggravated battery against a law enforcement officer in September 2020, Your Honor. For those reasons, we do believe that the defendant has a propensity of violence, and he is also a possible flight risk as he has FTA'd on those Fulton County charges 4 times in 2019 alone. For those reasons, we are asking the court to honor that preset $5,000 surety bond. Nothing further.
Why wasn't this brought before the court yesterday, if he was here yesterday?
The state was unaware of this case yesterday, Your Honor. I am not for sure what happened, but I remember I worked up that case yesterday as well, and I didn't even see anything for this under Mr. Stevens' name.
These were very similar circumstances that I remember from yesterday. What bond did I give him yesterday?
Let me check 1 second, Your Honor.
He received a $2,000 signature bond through the jail.
That's what he advised me, Judge.
Okay, all right. Thank you. Mr. Murphy?
Judge, the alleged victim has a criminal history, numerous incidents. I concede that my client, this isn't his first day at the rodeo, but he resides at 1584 Campbellton Road, Atlanta 30311. He resides with his mother. This incident allegedly occurred at his sister's house allegedly involving his niece. My client's mother is Barbara Coffin. He'll stay there and remain there pending the outcome of this case. He's age 39, he's a 10th grade education. He has no other discernible assets. The court has already adjudicated an earlier bond. I'd like the court to consider something in the same direction, Your Honor. Okay. And I'd add that the 2 addresses at issue are nowhere near each other. My client's address, I think, is APD Zone 4, and the other address is APD Zone 3. So I'd ask the court to consider what it's done previously yesterday involving a reasonable bond.
All right. I agree with Mr. Murphy. If this had come before me yesterday, I had a reason for the $2,000 signature bond through the jail. He's been in jail in custody for another. Is he only in custody on these charges? Or on this charge? Is he been held for anything else?
I believe this may be a probation violation as well, Your Honor. But I'm double checking now.
I don't want to go through, like yesterday, if we had handled the cases together, he might have gotten out yesterday. He's been in jail for a whole nother day today, since yesterday. So I don't want it to come back tomorrow that he has something else holding him in that we could have dealt with or not dealt with.
I don't see any other holds based on what I'm seeing on the jailing screen, but I do know that he did have those 2020 cases, and I know he was offered probation on one of those. So I'm not for sure if these offenses will cause a probation violation that may hold him, Your Honor, because those cases are out of Fulton County.
All right, so it's going to be as yesterday, a $2,000 signature bond through the jail. No further contact with Ms. Coffin. Stay away from the University Avenue address. No drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Stevens.
Judge, thank you for the grace of the court. And Mr. Stevens, remain at that location and do what's required under the law so we're not back here. Thank you, Judge. And Mr. Stevens, I'll dispatch some communication to your address. Look forward to the next several days. Thank you, Judge. I believe that's all I had. The other case was the Thad Rucker, but I understand that was transferred. So that's all I have now.
All right. Have a good afternoon. We'll see you next time, Mr. Murphy.
Thank you, Judge.
Thank you, Your Honor, Mr. Morrow.
You're welcome, Mr. Stevens. Have a good day.
Outro. Yes, sir.
Okay. All right, who do we have next?
They'll be going.
Courtroom 2, you all done? Okay, thank you. Judge, we have position number 9 in courtroom 3, please.
Okay, this is Ms. Wiley. Good afternoon, Ms. Wiley. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Wiley, you've been charged in case 22 CR 001636 with terroristic threats. Is there a history, Mr. Howard?
No.
2020 misdemeanor possession of marijuana.
Okay. Ms. Duncan?
Your Honor, this incident took place on February 27th, 2022 at 1631 Stanton Road. We have number 0-5 Southwest Atlanta, Fulton County. The victim in this case is Willie Mealy. We have it at Willie, common spelling Mealy as MEALIE. In this case, Your Honor, police were dispatched to the location several times on this date. They encountered the defendant in this case because she has a child with the victim's son. And according to what was told to police officers, she was upset about a recent breakup that she had with the victim's son, and she threatened to break all the windows in the apartment and shoot up the apartment. There was a neighbor who lives upstairs from the victim in this case, Nicola Lawrence, who heard everything that was said and the statements made by the defendant in this case. And the victim was able to confirm the defendant's identity in this case from a photo that was presented. Given the history, the state is requesting in this case a $2,500 surety bond. No further contact with the victim in this case, a stay away from the incident location, 1-day anger awareness, and no alcohol, drugs, or weapons.
Hey, Ms. Kim?
Yes, Your Honor. Ms. Wiley is 27 years old. And actually, Your Honor, on that day, she had 2 friends and sister in the location who can testify that the neighbor is lying or mistaken. Willie Mealy does not have any relationship anymore. Miss Wiley actually has another fiance, and that fiance passed away on November 5, 2021, and she was grieving her fiance. She was not sad about breaking up with Willie Mealy. And also, Your Honor, there was new girlfriend of Willie Mealy who has been continuously harassing her and her mom, her sister, and her children through texts and Instagrams, phone calls, and all kinds of harassing communications were going on. So, and then she was actually provoked on that day. So we would like to, I think there's a lot of misunderstanding, and also she denies all the allegations completely. So we would like to request for a signature bond. And that's it, Your Honor. Thank you.
Okay, it's going to be $1,000 signature bond through pretrial, 1-day anger awareness class, no further contact with the alleged victim, stay away from the Stanton Road address, no drugs, alcohol, or weapons while out on bond.
Yeah.
Yes. All right. Your question?
No, I'm just saying thank you.
Oh, okay. Thank you. Good luck to you.
Your Honor.
Which I think that's all we have here today.
Okay, what about position number 1, Angel Evans?
Hold on one moment for me, okay?
Okay.
Your Honor, position one bonded out.
Okay, thank you, Ms. Gann.
You're welcome.
I have Ms. Bridgewater in court with me today, and when she's ready, we'll go over the calendar.
Okay, good afternoon. Again, the reset date for SAP is going to be April the 5th. Position number 1 is reset to further notice as they bonded out. Position 2 is reset to the SAP calendar with a $1,500 good bond. Position number 3 is reset to the SAP calendar with a $2,000 good bond. Position 4 reset to the SAP calendar, again, a $2,000 good bond. Position 5 is reset further notice with a $2,500 SOB through the jail. Position 6 reset further notice with a $2,000 SOB through the jail. Position 7 reset further notice with a $3,000 SOB through pretrial. Position 8 reset to the SAP calendar with a $3,000 good bond. And position 9 reset further notice with a $1,000 SOB through pretrial. Are there any questions, comments, or otherwise?
And position 1 bonded out, I understand.
Yes, Judge, she made bond. Thank you.
Very good. All right, thank you. Thank you all. Any questions, comments, concerns?